All right, so a very big thanks to Asantiwa and the team for bringing us the WoezorTV Breakfast Cafe. It's time for us to head into your favorite current affairs program, the dialogue right here on WoezorTV. My name is Randy Ahadzi. Of course, this morning on our discussion table, we taking a look at the OSP versus the Attorney General, and we're asking a simple question: is legal ambiguity weakening Ghana's, anti-corruption fight? Remember that the fight against graft is a major one for the current administration. But I'll give you a background to all that you need to know as far as this particular topic is concerned. If you recall, earlier this week, one of the high courts here in Accra has ordered the Attorney General to immediately take over all criminal prosecutions currently being handled by the Office of the Special Prosecutor. That was actually what the ruling sought to achieve, and also pending formal authorization from the Attorney General's office. Now, in its ruling, the court also declared all ongoing prosecutions initiated by the Office of the Special Prosecutor null and void, effectively halting multiple cases across various courts. And I'm going to break down a little bit of the cases that the Special Prosecutor is handling as it stands now. What are some of the effect this ruling can have on these cases? Now, additionally, let's be clear on it. The court also awarded cost of 15,000 Ghana cedis against the Office of the Special Prosecutor. Now, where from all of this? The decision stems from a case involving 4 individuals under investigation by the Office of the Special Prosecutor, including Ahadzi of the National Insurance Commission, James Kirk Osei, a former director at the Office of the Vice President, and customs officers John Abai and Peter Archibald High. Now, the individuals are accused of conspiring to seize containers using forged documents and a falsified letter purportedly from the Office of the Vice President. Now, it is also clear that Peter Archibald, one of the accused, filed a judicial review application seeking to quash the OSP's decision to prosecute. Now, what happened earlier in the week? In delivering the ruling, the judge held that while the OSP has the mandate to investigate suspected corruption-related offenses, it does not have the authority to initiate prosecutions without prior authorization from the Attorney General. Now, the court also therefore ruled that all such prosecutions are void and must be taken over by the Attorney General. Now, we also know that the Office of the Special Prosecutor, in a statement, said the ruling conflicts with an earlier decision by the Criminal Division of the High Court, which had which had actually deferred a similar application pending a Supreme Court determination on whether the OSP can independently initiate criminal prosecution. So it looks as though the argument is that some believe we have gone back to so many years. This is more like a retrogression. Others believe that yes, constitutionally, the constitution was upheld in this particular ruling. But the question again I ask is, what happens to some of the major cases that the OSP has already been dealing with? And I'll run through some of them quickly before I bring in my guest. You can talk about the Mustafa Abdul Hamid and 9 others issues that is still pending. On 23 July 2023, the office initiated criminal proceedings in the High Court against Mustafa Hamid, who happens to be a former executive or chief executive of the National Petroleum Authority, and 9 others, including 3 corporate entities. There is also another case involving the Republic versus Issa Seidu and 3 others. You can also talk about the Republic versus Charles Bissiu and another substituted with some other case as well. You can talk about the Republic versus Charles Bissiu and 2 others. There is another case also that the OSP is working on, the Republic versus Ibrahim Kofi Sessa, and quite a number of them, and it goes on and on. Now, the other big one that a lot of people are talking about has to do with the former finance minister that everyone in the country has been looking for. What happens to that particular case also? That's a conversation we should be having this morning. And glad enough, I've been joined on the lines by Professor Enoch Opoku Entry. He's a governance and a leadership expert. He's joined us via Zoom. Prof, good morning. It's morning here. How are you doing?
Yes, it's also morning here. Good morning. How are you?
Hello, Prof. If you can mute for me, I can't hear you, Prof. Good morning. Would have to rectify that. Whilst at it, let me also welcome Council Martin Pebu. He's a private legal practitioner and he has a keen interest in this particular conversation as well. Counsel, good morning. Hello, Mr. Pebu. Good morning.
Morning.
Very well.
You can hear me?
Yes, I can hear you. I can hear you now. It's very much clear. Thank you so much for joining us this morning. Let's go straight to the point with regards to this particular topic. Counsel, from where you sit, I mean, when this ruling came earlier in this week, what was your preliminary reaction?
Oh, that it is good riddance. Good riddance. It's a sweet decision that's helping us to hold the special prosecutor accountable, because so far he's had a free rein doing what he likes and abusing this in the law. Abuse of power would, when there is a case involves 3-4 people, he would choose those he likes and then leave others, even when the others are very much involved in the crime, etc. So there's a whole lot of rot that the special prosecutor is undertaking, bad governance of the office. So this decision has helped, and straight away, let's not mince words. We'll beg President Mahama not to intervene this time again. We'll beg President Mahama not to intervene. So far, it's showing that President Mahama is overprotecting Kissie Jabin. It's not good for our democracy. Let Kissie Jabin face the law. So far, President Mahama is overprotecting him. Listen, let's make this very clear. My understanding is that President Mahama has a soft spot for Kissie Jabin because Kissie Jabin cleared him in the Airbus matter. But there was nothing in the Airbus matter, not a criminal standard. There was nothing to a criminal standard. Yes, some things went wrong in the Airbus matter, but it didn't reach the level of a crime. That's how come President Mahama was not prosecuted. But it appears because Kissie Jabin cleared him, President Mahama is excessively protecting Kissie Jabin. It's not good for our democracy. Let Kissie Jabin face the law. Let him face the law, because, look, the fact that somebody is put there to fight corruption doesn't mean that he himself cannot be corrupt. We see it. We have a lot of information. The way they're just doing it, that President Mahama will protect Kissie Jabin. It's not on. It's not good for our democracy. It's not good. If the special prosecutor is breaking the law, let him face the law. Don't say, oh, Kissie Jabin once cleared the president, so because of it, then anything Kissie Jabin does, oh, it's okay, it's okay. It's like payback. It's like a payback. No. I'm very upset this morning. From what I'm hearing, the efforts to protect Kissie Jabin again this time, it's not good. I'm extremely upset. The president kindly should know that people are watching. We hear things. We hear a lot of things. So we are begging him that this time he should stay off. Let's use the law. If Kissie Jabin is breaking the law, he must face the law. Don't use any other things like some CSOs. You see, you hear some CSOs on air supporting Kissie Jabin. Look, we will soon investigate everybody, and you will find that some of these CSOs have special interests. Some have their kids appointed in the office of special prosecutor, etc. Other kind of considerations. We'll do an audit. Of the employees in the special prosecutor office, and you see where they come from. Then you understand the kind of noise some CSOs are making. I mean, this is nauseating. We say we want to fight corruption, and the people who are supposed to fight turn around and are engaged in all manner of conduct that don't help the fight. And we think just because somebody has formed an organization and says it's an anti-corruption campaigner, it means that yes, he's really fighting. It's a joke. We will audit the employees of the special prosecutor. Let's find out who are their parents, who are their uncles, who are their aunties, etc. Then you see the true picture. That some CSOs are just out there to further their own interests. It's not about any fight against corruption. It's just about personal interest.
Okay, let me rope in my other guest as well. I'll come back to the issue of the argument that people make that the Attorney General already is overwhelmed with a lot of cases. And now taking off that particular role from the OSP will even burden the Attorney General. I'll come back for clarifications on that. But let me rope in Professor Opoku Entry as well. Let me pick his reactions to all that has popped up within the week. Prof, good morning. Thank you for joining us once again.
Morning,
your reactions, listen to Mr. Pebu as well. What will be your...
Yes, Martin, I've never seen Martin angry like this before. And it seems he has personal vested interest in this issue. He talked about rot. He talked about being upset and the auditing that he's looking for. If you say it's a legal ambiguity, I'm saying that it's a legal oversight. not an ambiguity, but a legal oversight. Why do I say so? Because the ruling creates an impartial or impractical expression, even though it is rooted in the Constitution. So a couple of things that people need to understand. When issues come like, we should take a step back, just a step away from the Tower of Babel where there was confusion, and then begin to analyze them one by one and see where we stand. First, there is an Article 959, which mandates the Office of the Special Prosecutor to prosecute corruption and its related offenses. So these are mandates given by the LI, which was passed by Parliament in 2021. Now, I'm not talking about 2021, but 2021 that this Kissi Agyabin was vetted and then sworn in. But the Constitution of Ghana, the 1992 Constitution, gives or vests all prosecutorial powers into the Office of the Attorney General. So it appears that the Article 88 is outsourcing some of its powers or prosecutorial powers to the Office of the Special Prosecutor. Now, that is not the Special Prosecutor's fault. So the question now is, what kind of corruption issues have the Special Prosecutor been able to adjudicate and fix since he came to office or he was vetted? I'm talking about Kissi Agyabin in this context since 2021. Not many have been done. But people are asking themselves a lot of questions. That is it a way of hacking out the OSP? Do people want to take him out? It is taking us back on corruption fights and all these. Now, the fundamental thing is that there seems to be a duplication of effort and resources. So if the Constitution has given the prosecutorial power to the Attorney General, why does the same Constitution give similar power to the Office of the Special Prosecutor? And then we step again and ask a question. If two individuals are doing the same thing to fight corruption, is it going to harm us or is it going to help us? And I think it's going to help us because for far too long, we've had a lot of corruption issues in the country. But this is the catch. The Attorney General seems not to be happy about the Office of the Special Prosecutor, how they are handling these issues of prosecutorial powers. So they want it for themselves. But then another question comes in. We have what we call collective responsibility in political parties. Anytime a political party wins a power, you come with your people. And does the Attorney General have the goodwill and then the fairness and then the boldness to prosecute people of their own political party? That is where the question comes in, because you have a collective responsibility. And how can you prosecute your own? And these are some of the questions that people are asking, because it raises questions of fairness, impartiality, public confidence in the judicial process. And some of these questions, people need genuine answers to them. So let's step out. And I'm hoping that the court stays away from all the politics and, stick to the facts. And when we stick to the facts, it will be clear for us to explain this to the public about what needs to be done and what we shouldn't do.
Hold on, I'll come back. But let me bring back Mr. Kpebu one more time on the issue of the Attorney General being overwhelmed with cases. Mr. Kpebu, don't you agree that, taking off this role from the OSP, we even overburden the Attorney General? Hello, Mr. Kpebu.
Yes.
Okay. Yeah. Please.
Now let's say this. Yes. The Attorney General being overburdened.
Yeah.
Yes. So it's something I basically subscribe to. That yes, as for the Office of Special Prosecutor, it should be maintained. Let's maintain it. The problem we are facing now is about how to hold the Special Prosecutor accountable, sort of saying that each time there's something wrong, you present a petition and say the person should be removed. No. It's about how we will put in place a better law to be able to ensure accountability, a better law to be able to ensure that we don't get selective justice. Like the way Kissi Agyabin allowed Ufuriata to flee this country. You see, Ufuriata, who had 5 cases, he allowed him to flee. Like the way Kissi Agyabin failed to arrest Kingsley Agyman, the MP for Ebuakwa, is it SAF? He replaced Atachia. He was involved in corruption. He used scholarships, scholarships to give somebody to smear Atachia. The case is there. The documents are there. If you want, we show them on TV3. If you want, after this program, you can contact me. I'll forward them to you. Yet, because Kingsley is tightly linked to Kisi Ejabin, he said they shouldn't arrest him. If not, he will lose the election in 2024, etc. There are many cases that you find that no, the special prosecutor is not fighting corruption, but he's only promoting it. So my argument is that, yes, we need the office. We need more offices, but we just don't need the office. We need the office plus law that will hold the officer, that's the manager, that's the chief executive, that's the special prosecutor accountable. Because anytime you say any listing, you go and present a petition. The process for presenting a petition, the trial, etc., is so long. Why don't you put in place laws that can prevent the abuse? So, for example, now let's go to specifics. Now, when a petition is sent to the Office of Special Prosecutor, currently under the law, you address it to Kisi Ejabin. So, Mr. Host, what's your name again?
Randy here.
Host, what's your name? Randy.
Yeah.
So, if Randy, you present a petition against Enna, when the petition goes to Kisi Ejabin, and Kisi Ejabin likes Enna, he can sit on the petition and slow it down, go slow, not cause it to be investigated, etc. A typical example is the Oforiatta case. Oforiatta case, they presented it SML in December 2023, right?
Yeah.
For over a year. He said that didn't cause it to be investigated. He waited till January 2025 when Oforiatta had voted before he started. That one today is a document that shows it. It's called the Diary of Action. The first time that a formal step was taken to investigate, it was on 29th of January 2025. But then Oforiatta had run away for over 3 weeks. So these are the rot, these are the bad things, these are the bad governance going on in the Special Prosecutor Office that I'm saying this decision has helped us to continue to debate. So we need to change the law. We also need to, so in the new law or amendments, we want that when a petition goes, it will go to a committee, maybe 12 apostles, 12, or like a jury, 7. So that, and it should also involve people who are not employees of the office, who are not board members. We want some independence. So that when they all see the petition and they think it concerns corruption, they will be tracking it so that it will get investigated. Not the type that Kisi Ejabin got the SML petition and sat on it to Oforiatta absconded.
Okay.
You see the thing?
Yeah.
So that is the thing. And also how the special prosecutor reports to the office. We need to amend the law so that it will be more detailed. More detailed. If it was more detailed, this SML matter that wasn't investigated, the public could have seen something going wrong. But because of the manner in which there's no detailed guidance on how he should report, we couldn't track it well before we realized the problem had been created. You see? So, number 3, we also need to change the law to make corruption there's a reverse burden.
Okay.
So that if we catch you with money, like Cecilia Dapa, we presume that it's corruption money, unless you yourself, you prove yourself innocent. Okay. That's the law we use for narcotics.
Okay.
Randy. Yeah. You, Randy, as host, touch wood. If you were found with 1 roll of weed in your pocket, marijuana, when it goes to court, simply you are guilty until you prove yourself innocent.
Yeah.
Yes, because unless you prove that the Minister of Health gave you a permit to have the weed, you are in trouble. Yeah. So the corruption one, we need to change the law so that if we catch a minister, any public appointee, with plenty money like that, the presumption is that it is corruption property or corruption money or corruption asset. Then it's for the person to prove that it is not. That's the law. If this one is not new, that's the law we use in Kwame Nkrumah's time to deal with corruption. So we are just going to do Sankofa. Okay, so these are 3 major things that I think we can do by way of amendment. I have to enter court now. You know, it's 9 o'clock.
Okay, so let me take your final bite on this particular one. Moving forward, the OSP mentioned that he is going to more like fight this. There is going to be an appeal on it. Is it a much ado about nothing?
No, that one I cannot say so. I cannot say so because it depends. You see, when it comes to law, you see how this judge Eugene Nyante, Justice Eugene Nyante has ruled that OSP should hand over the cases, etc. You can find another judge who can look at the same case and say, no, there's nothing wrong. OSP, Triaso, OSP, Tiaso, OSP, Tiaso. So what I'm saying is that in law, we have different schools of thought. So it depends on the judges that will deal with it on appeal.
Okay.
But if you ask me, instead of the appeal that he said he may do, it appears that the Supreme Court may deal with the Noah Tete case earlier. If you look at the processes to do appeal, it's likely to take longer. But the Noah Tete case in the Supreme Court, I'm sure within 3 months, the Supreme Court can deal with it. So maybe it would be better we concentrated efforts on the Supreme Court, what the Supreme Court will say. But please, Randy, as I'm leaving you today, I want us to be careful. The fact that somebody creates an organization and begins to say he's fighting corruption, it doesn't mean the person is really fighting corruption. In no time, he also joins in the corruption. So be careful. We should be careful. People will be branding themselves, I'm anti-corruption. Let's audit, I'm telling you, let's audit the OSP and see who and whose wards, who and whose friends and families did he appoint. Then you will see that you don't have a fight against corruption. Some people are just pretending and deceiving the rest of us. But time will catch all of them. They should wait one by one.
Okay, very well. Counsel, thank you for your time this morning. We would have to let you go. We wish you the very best of luck as you head into court as well. But let me bring in Prof one more time. We're expecting to speak to Dr. Jonathan Asante-Okyere also, who will also be joining us right here on the show. But Prof, Mr. Kpebu has stated quite a number of things. Don't you think this precedent probably will linger on in the future generation? That's one. Two, does this not set a bad tone for us that anyone at all can write a petition against public office holders and then the court rules? I'm still thinking about what happened to the former Chief Justice, Prof.
Yes. You see, justice is something given to the Creator. It's God who do justice to everything that happens to us. And we human beings, based on education, select individuals who we expect to be fair to do justice to issues like this. Martin raised a lot of issues that is interesting. He talked about anti-graft corruption agencies like Transparency International who have fighting corruption perception indexes and all those things, that some of these organizations are not fighting corruption. If you create that impression that non-profits who are genuinely fighting corruption are not fighting corruption, but they are working under the guise of some institutions, then you are raising a lot of issues. And when you make allegations, you need to, he being a lawyer, you need to really prove it. I am worried that the perception being created out there that there's a public execution of the OSP, and that might not be the case, because the Constitution clearly states that all the prosecutorial powers are vested in the Attorney General. Now, the problem is that the Attorney General is appointed by a ruling government. Now, if we have a government, it's the political party that creates a government. So NDC political parties created the government of NDC in power. The same way MPP political party created the government of MPP in power. So everybody under the umbrella, or anybody following the Osono, the elephant, once one is appointed to be the Attorney General, you are one of a group of a political party. So how do you prosecute one of your own fairly? Because you have collective responsibility. The Attorney General's acts and actions are all in cohesion with the political party that he comes from. So that is the caution there, and that is why we need non-profits and others who are fighting for corruption. If you have many agencies fighting for corruption, it's all for the common good of the people. But let's go back to the Act of Parliament. Parliament really make laws. By our Constitution, they make laws. So Parliament created an LI for this OSP office. Now we are saying that there's a problem with that, because that power, all of it, should have been given to the Attorney General, but not some of it being given to the OSP. So what do? We go back to Parliament to amend that part. But a High Court judge, I don't know the authority of a High Court judge to say that me being a judge interpreting the law is saying that all the prosecutorial files should be given to the Attorney General. I think that is wrong. It is wrong. Legally, it is wrong. Common sense, it is wrong. What needs to be done is the Supreme Court to interpret it and make a jurisdiction or judgment on that, a ruling on that, not a High Court judge, because High Court is one person's opinion. Now, when it goes to the appeal court, we have three individuals, three
individuals' heads are better than one. When it goes to the Supreme Court, it's 5 or more. So we need more judges brainstorming to think about this prosecutorial power instead of just a high court ruling. And I don't know why we are, as a nation, running skelter-helter because of just one individual judge's opinion. Because his opinion is out of 34 million Ghanaians, even though he's a judge. So I think that, yes, we should all calm down. The board, think about the constitution, the law that we have. Do we all agree as a nation that all the prosecutorial laws of the criminal code should be given to the attorney general, who is appointed by a ruling government? And would that attorney general be fair to everybody when there's a criminal case? Would that person be fair in judging a case in either NDC or NPP or any political party in power? These are sensitive questions we should be asking ourselves. We shouldn't make it a politics, because the court should focus on the facts, not the politics. And once we bring politics into the facts and making adjudication, then the people, the common man on the street, get confused. So yes, let's go back to Parliament. Parliament made that law. So if a high court judge rules based on that law, he's not made any mistake. That's the fundamental of it. However, it is up to Parliament to make an amendment, or the Supreme Court to make a ruling, so that we go back to the same LI and make some amendments. So as we speak now, the 1992 Constitution gives wholly all the powers of prosecutorial powers to the Attorney General. But the same Parliament also sat down and gave similar powers to the OSP. So if the OSP is not meeting our expectations, that's a different ballgame altogether. We're talking about powers, prosecutorial powers. So if Parliament erred from the beginning by giving or outsourcing some of these powers to the OSP, and we think it is not fair enough, it is up for us to fix it. It's just a simple matter.
Minority also issued a statement on this, and they mentioned that the court erred in this particular ruling. I'll come back to you on that, but let me bring in Dr. Jonathan Asante Ochre, who is the Executive Director of the African Institute of Strategic Studies and also a senior lecturer. He's a political analyst. Doc, thank you. Good morning.
Good morning, my brother Andy. How are you doing?
I'm fine, and you?
I'm doing okay.
Very well. Let me just pose the question straight to you. You have followed this whole thing right from the very beginning to where we find ourselves. Now the ruling is out. Some say or argue that this will actually erode the gains we have made so far with regards to the quest to fight against graft. And mind you, it has become one of the major factors that, contributed to the victory of the NDC prior to the 2024 elections. What do you say about this ruling?
Well, I'm not too sure if the judge, in actual fact, engaged in interpretation of the Constitution. What he actually did was just an administrative principle. And that principle is enshrined in the article that establishes the OSP. And so I'm not too sure if the judge erred on that side of interpretation. That is one. Two, it is established and the principle is stated as far as Article 88 is concerned. I think that many lawyers have spoken about that, so I'm not going to repeat that. It is very unambiguous with respect to that particular article. And then what it is also found in the OSP, article, so to speak, that founded it, is expressly stated that for anyone, including that office, to engage in the prosecution of any sort, you need the express authorization of the Attorney General. That is unambiguous. But then, the question is, we need to go into the practicality of what is happening now. The practicality, as I'm foreseeing it, is the fact that there is some kind of ego clash. Forget about the principles that establish both offices. There is an ego clash somewhere. Someone thinks that his independence must not be compromised in any way. Apart from that, politically, someone also thinks that asking for authorization from the Attorney General's office in itself compromises my independence. That in itself is another problem or a hurdle that practically ought to be crossed. Now, this morning, the question I asked myself, okay, if it is expressed that within the Constitution, the word that they use is sole, the Attorney General that has that authority. When you write as an OSP, can it be declined? If it can be declined, then it means that, as I said, there is some ego clash somewhere. There is a clash of interests. And of course, the state, the state has a preeminence over individual egos. And that's the more reason why we need to look at it from a practical perspective. The point is that if you look at the history, the trajectory of how that office was founded, it was wrong. Because the assumption was the independentness of that particular office. But in that article, which some of us argue, as long as you have an article that says that the Attorney General has the authorization to give, then that office is not independent. So what I'm seeing, or what I saw in the previous period of the former president's office, so then it means that if you have an OSP nominated by an Attorney General, appointed by a particular sitting president, then it means most likely they can work without any problem with that sitting Attorney General, because there is a more likelihood that because he was nominated and appointed by this very president that nominated and appointed the Attorney General, it means that in terms of administrative bottlenecks, those things can easily be ironed out. But what I'm foreseeing, which I told you earlier on, with respect to this ego clash, is the fact that we have a situation where the current Attorney General, nominated and appointed by the sitting president, the current OSP, nominated and appointed in the process by the previous president, then how sure are we that they are aligned in terms of achieving a particular goal? You see, we need to equally look at some practical issues that are happening. Is it possible, I'm hazarding a guess, is it possible that the OSP has intentionally handled the former finance minister's case? And you know that when they say the law is an ass, it is because of procedures. Now, if you get certain things procedurally wrong, you may have a good case, but they may throw your case away from the court. Those are some of the issues that probably rearing their ugly head with respect to this particular case. Don't also forget that, of course, it was a private individual who initiated something of that sort, while others may hazard a conspiracy theory that maybe somebody else is behind. I don't have that kind of evidence, so I wouldn't want to go on that particular tangent. But if we look at the practicality on this same issue of the authorization, is it possible, per the architecture of the OSP, is it possible that when he writes or she writes, not referring to anybody in office, when he or she writes to the Attorney General asking for express authorization, Attorney General gives, is it possible that in the course of the process, the Attorney General can withdraw the authorization? If the Attorney General can equally do so when he is granted it, then there is something mischievous about the law that, established the OSP. In actual fact, it is becoming impracticable as the current architecture of our jurisdiction is concerned.
Some other points, but Prof, let me bring you in. You listen to Dr. Jonathan. he's enumerated quite a number of things. He mentions, I mean, he keeps mentioning the issue of clash of ego here and there. If you check carefully, there could also be interest, most especially when indeed a special prosecutor was appointed by the previous administration, and indeed quite a number of people in the current administration keep criticizing some of his output. Now, there is also another angle to the Attorney General, who is largely appointed by the current administration. Do you foresee some external interference in the role the Attorney General will prosecute some of these cases?
That's why many people have asked the question that whose interest does this serve? Or if the current government feels that the OSP is not serving the interests of the government and in a way sabotaging them, citing Oforiatta's case and then many of the cases that you also talked about, then we have an issue, because the Charles Bissiou issue, the Mustafa Hamid issue that you talk about are all pending in out there. So is it a case that the Attorney General feel frustrated that these criminal issues are not being taken care of as they want it to be? So they want to take from the OSP and then handle it themselves. So a lot of people have been asking this question about interest here. And then he brought in the word ego. One thing that I know, being a professor, is that when you get into a room full of egos, individuals who are highly achievers, you need to work on how you build relationship. And the law works in such a way that you also build relationship with the people and explain it to them so that the common person on the street can understand. I believe that if you create the impression of interest, that the government has so much interest in these issues, and the OSP is not helping the government to achieve the goal that they want to achieve, then they are using the High Court. That's the impression being created. They're using the High Court to get those files so that the AG can get them and then act on it. We have the law of diminishing returns in economics that works everywhere, where there's duplication of effort and resources. So what is happening is that the same prosecutorial power is given to the Attorney General. Some of it has been outsourced to the OSP by the LI that established the OSP, and that is Act 959, Act from Parliament. What it is doing is that it is computing with the 1992 Constitution of Article 88, 1, 2, 3. So people have problems with it. So is that the reason why the special prosecutor must sit idle and do nothing? Because I heard one of the scholars saying that he should not even appeal, he should not even talk to the media, just sit down and collect your salary. That is words of frustration to some scholars to see that the office we all created with jubilation, thinking that it's going to fix, is being scrapped after almost 8 years. So did we go or did we come, just using street language? And I say bye. Now, to avoid that, what we have to do is that we have to make sure. I was of the opinion that even we have Shraj and other institutions who were all helping the corruption issues. Yoko is there, but still corruption is endemic, in our psyche and as a society. So creating more organization to face the corruption shouldn't have been a problem. But there seemed to be an interest. And the interest seemed to be focused on what the government wants to do in the reset agenda and what the OSP is not helping the government to do. If that is the case, nothing stops those who petition the president to take the current OSP out and bring somebody who can align with. But I'm also not comfortable with the word alignment. In law, we're talking about individual independent judgment. It's not about who aligns with the government, A or B. That is why I'm a little bit worried about the constitutional review recommendation that came. There's not been any white paper on that. I was thinking that the way they did it was going to help fix our problem, because that constitution is our biggest problem in the country. And you see, all these holes in the constitution is creating the problem. Let's fix that constitution so that these problems will not rise in the first place.
Hold on a second. Doc, let me bring you in again. Now, I am worried, and to a large extent, I think my peers will also be worried that the ruling also spoke about the fact that all prosecutions being done by the Office of the Special Prosecutor are now null and void. Again, the question about having the Attorney General go through some of these burdensome cases is a major headache. Have we gone? Have we come back, like Prof mentioned?
Well, I see this, and I see this as more of an administrative lapse. Uh, I think that the OSP went on the wrong for assuming without admitting that the independent entity that has not been upheld by the Constitution, especially with Article 88. But that being said, well, with or without the OSP, the Attorney General has been in a position to be handling all these kinds of issues from time past up to this point. This one may not be anything new to suggest that the current Attorney General is not in a position to do so. What I think ought to be happening is the fact that if we say we are law abiders, and the constitutional provision states in Article 88, it is incumbent upon the OSP, not the Attorney General, to grant that particular authorization. They must write. That is why I felt that if two angels are working for God, why should there be a conflict? If two angels, after all, our master is one. But you see, if you ask yourself, if God and Satan had the same power, what do you think would have happened? It's just a theory that I'm hazarding. Whichever way you look at it, the Attorney General does not necessarily have to disagree with the OSP if they are equally fighting for the same principle, that is, for the good of the state, and vice versa. By that, the OSP does not have to have any conflict with the Attorney General, especially the one that is supposed to give you authorization. So it was not a given that the moment you have that prosecutorial power, you just start prosecuting. That's why I said that probably at the top level, others have sat down to think that let's look at the cases that he is prosecuting that have emanated from the previous regime. What about Cecilia Dapa? What has become of that? This look at the Pandai, the MP of Pandai I like so much. But you see, if the law says that 32 days after, is it 21 days after the gazetting, you have no business challenging that. The court there internally felt that these anomalies warranted a rerun or a by-election. But the law says that they filed their case 32 days after the 21 days had elapsed. Technicality. So look at the number of technical errors that the current OSP has committed with respect to Kano Furiata. So is it intentional or unintentional? These are some of the questions that you may be asking. So at the end of the day, nobody can deny the fact that Mr. Kano Furiata's arrival and subsequent prosecution provides a key to a number of cases that the current government will want to unravel. And that is part of their mandate with respect to ORA, or accountability in general terms. So if you have another prosecutor who, in the minds of the main prosecutor or the one whose office you need to get authorization from, maybe they are not in any way working towards a particular goal that is to the interest of the state, then definitely there will be some kind of ego clash. So administratively taking over the cases and other things, what stops the OSP from doing so? If the OSP does not do so, then it means that he has an ego. He has an ego, and in actual fact, the constitution, the legislation that created that particular office, he is acting ultra vires. If in the previous regime they glossed their eyes over that authorization, just because the people who were nominated and accordingly appointed were virtually, so to speak, on the same tangent with the then government. Probably that's the more reason why they might not have used this, or they may not have sought that authorization, because Gloria Kufu did not do so. I'm not too sure if Wilfred Adami equally did so. So, as I said, it is not a given. And in actual fact, you need to particularize what is happening, put that in a particular proper context to appreciate exactly what is going on. That is why I said that if you get, when they say that law is an ass, it is not just about having your fact right. It is equally about getting the procedures right. And the procedures are wrong. Obviously, a good case may even become a bad one. And so we don't have to detach from the fact that there are some practical reasons, practical challenges that probably the current Attorney General is facing, for which reason they may want to, do some of the things that the court has mandated them to do so. So I believe that it is much ado about nothing. As for the bottlenecks, they are there. They've been there over the period. All what I believe the OSP ought to do, if he doesn't feel that is experiencing a puncture of his ego, I think all he has to do per the Constitution is right. Seeking authorization, case by case, not just carte blanche, case by case, the administrative hurdle that he has to cross from the Attorney General. Let the burden of guilt be on the Attorney General to let us think that in this particular case, which falls under corruption and corruption related, I've sought for this authorization. The Attorney General has declined. Now that in itself could easily unsettle the Attorney General if the procedures are right and the motive is equally good, not a matter of malice.
Let me bring you in, Doc. Hold on, I'll come back so that we wrap up on this. But Prof, let me bring you in. Now, if you look critically at the manifesto of the NDC prior to the 2024 elections, they were very rife on key statements made as far as contributing to the success of the OSP is concerned. I mean, and they were very emphatic that they will ensure that they empower and strengthen the office of the special prosecutor. Is that what we are seeing today?
Randy, is a very good question. Empowerment means we are strengthening the hands of the OSP and the office, resourcing them with the tools to work so that they can face corruption, which has caused us a lot of things. If you look at the Auditor General report and what is going on at PAC, it means that we have internal money that we could have used. Same as Tanzania is using their sinking fund. They've paid all the debt to IMF. So they don't owe anymore. And this is a woman president. So there are many things we can use the money that is going to individual pockets. We can use it to fix our roads, our hospitals, and our schools. So if you say you are strengthening the hands of the office of the special prosecutor, and then we are using technical processes of the law to make the official work of the office of the special prosecutor incompetent. So now it seems that he's not performing. He's not been able to perform the functions of fixing corruption. How many people has the special prosecutor sent to court? How many cases has he won? So these are legitimate questions. But why don't we blame our parliament for all this brouhaha? Because they were supposed to do due diligence and know what is in the Constitution before establishing the office of the special prosecutor. And if you do that with a hole in the Constitution, firmly saying that the Constitution vests all, the word is all, and all is a very powerful word, prosecutorial powers into the office of the Attorney General. Now the same parliamentarians who are supposed to make laws have given similar powers to the office of the special prosecutor. Now there seems to be that kind of duplication of effort and resources, which shouldn't have been a problem because we are all fighting for a common cause. But there seems to be that interest. Either it's a public interest or it's a political party interest or a personal interest. And it appears that the OSP has some personal interest that is standing in the way of this government in education of justice, especially criminal issues and corruption. And that is why the High Court has ruled. But going back before we can all have peace in the neighborhood, why don't we go to Parliament after the Supreme Court ruling for Parliament to fix that part of Article 88 to make sure that if Parliament says that now we made a mistake, we erred,
So all prosecutorial powers should be given to the Attorney General. Then what job does the OSP do? We should be able to face some of these things. And you can tell that from the inception of this OSP office, from Martin Amidu to Kisia Jaben, all of them have been unsettled. They have always talked about the challenges that they have. And I know at the vetting of Kisia Jaben, he himself expressed doubt about the constitutionality of the powers of the office. So from the beginning, he knew this was going to be a problem, and that has been used against him. So we need to face corruption. I am all for institutions that works, but it's still, yes, go ahead.
If you can hear me, that's my concern, because the previous or the former special prosecutor complained when he was in office. I'm talking about Martin Amidu. Now, Kisia Jaben also in the last, under the previous administration, raised quite a number of challenges he's faced in that particular office. Have we gotten to the stage where we say probably, look, we've had enough of the office of the special prosecutor. Let's just scrap that office off and then concentrate probably on the Attorney General and other anti-graft institutions. Should we not think about that?
So there's another fundamental challenge there. See, how come that, ask yourself this question, that how come that somebody nominated by Attorney General, appointed by the President, approved by Parliament, cannot work with the same institution? And no matter how efficient any individual is, if you are working in a corrupt system, corruption push back on you. So all these individuals who were put into that office have been frustrated. Why do we create an office and frustrate individuals who are working in those offices? That is the question everybody should be asking. I know Ghanaians, we all want to face corruption, but there are contentious issues. How do we fix it? So if we err in making this law and frustrating individuals put into those positions, why don't we go back to the drawing board and fix that hole in the Constitution that, okay, the Attorney General office have these prosecutorial powers, but we've also given similar powers to the office of the special prosecutor so that they can also chase the corrupt people out of town. If they are all doing the same thing and helping us face corruptions, because we're talking about overload, that the current Chief Justice is talking about even night courts and all those courts 24/7, because there are many pardon cases, go and come, corner bra, many cases. And people are losing trust in our justice system because of that. Somebody goes steal, a goat, a fowl, within 2 months, the case is settled, the person goes to jail. And some of these cases, nothing happens out of it. Talk about Ora, nothing has happened. So are we sure that when we give all the powers, the procedural powers to the Attorney General, then there is going to be a quick fix of that, it's going to go to court, and then boom, we are going to have a fix of our corruption? Are we sure about that? If we are not sure, then we should be careful in threading the way we distribute powers, because this is not a game of power and influence. It's a game of fixing corruption. The end product is fixing corruption. And when we do it this way and we give all the procedural powers to the Attorney General as enshrined in our Constitution, are we sure it's going to fix our corruption? That's the question everybody Ghanaian should be asking.
So we wrap up on your recommendations as well. But Doc, I told you we should wrap up on this. You listen to Prof. Again, we have to go to, do you agree that, of course, Parliament needs to review the laws that mandate some of these anti-graft institutions? And I have always been talking about the fact that we've had too many anti-graft institutions. I don't know if that is why we are finding so many bottlenecks. You can talk about the Yoko, you can talk about Shraj, you can talk about even the Ghana Police Service itself. They all seem to do the same thing. Time to review the laws that mandate these institutions.
Well, I think that would be a very difficult hurdle to cross as of now. Though we have different institutions that appear to have the same purpose, they seem to have been able to adjust to each other, and they have lived successively, traversing different regimes. And so, in as much as we seem not to have a synthesis of all these institutions that have that kind of mandate, I think we have not done badly. It is just that sometimes a particular case comes up and it becomes a source of confusion, for all of us. I believe that Parliament got it wrong at that time. There are others who expressed contrary views when the bill was passing into law. Others expressed pro, OSP's, what's it called, establishment and so on and so forth. Today, some of us argued in those years that if you say you are creating an office that is independent and still has its apron ties, strung to that of the Attorney General, then there is no independence over there. But as I said, if it is not a matter of ego clash and we are all working for the same purpose, and that is for the betterment of the state in terms of ensuring that criminals do not escape, in terms of ensuring that those who have laundered, those who have raped the state, do not escape, then I think that we are on the same page, and it is just much ado about nothing. The rest is just an administrative, issue that ought to be crossed, and that for me is the best way to go as of now, instead of creating another administrative ego clash where you say that you are now going to seek further interpretation of the Supreme Court. As long as that particular article has not been constitutionally amended, there is no way the Supreme Court can err on that particular matter. This is not to sound prejudicial, but I mean, you virtually tend to create a huge problem for the Supreme Court when the obvious is just there. So I don't know whether the current, Parliament will want to review the Office of Special Prosecutor, the law that establishes it, or the person occupying the office will have to follow the constitutional provision as stated, and that is to get authorization. Once you get in the authorization, as I said, once you are prosecuting something that in the minds of the Ghanaian is to to the benefit of the state, the whole population will be on your side. But if it is a matter of trickery, a ruse in the prosecution, where you intentionally create some of these procedural errors at the end of the day, just to delay the case and probably to a point where there is a change and then only prosecutors could be filed, then obviously there will be a clash between the Attorney General and the Special Prosecutor, because without the Special Prosecutor, the Attorney General was the one mandated still for some of these cases. So if you are doing it, then you must be seen to be doing it right. And it stops. There is nothing wrong if they are on the same page, because two angels worshiping God, it means that they are aligned to fight a particular cause, and that is Satan. So if you just oppose that to the state, serving the state, whatever we do is in the interest of it. And so you must be seen to be fighting things that are in the interest of the state. And if that is the case, I think that there wouldn't be a problem between the Attorney General and that of the Special Prosecutor. After all, we are on the same course, we are on the same page.
Concluding, the Special Prosecutor says he will file an appeal on this particular ruling. I asked Mr. Martin Kwebu earlier about whether this is much ado about nothing, whether this will go anywhere at all. Let me put that also to you before you leave.
I think I said at the cost of sounding prejudicial that filing an appeal when the thing is so expressly stated, I think that will be a mountain, a hurdle that he, may struggle to cross. Now, that aside, it's just like, as I said, there is some kind of ego clash. If the OSP intends to abide by the law, which he expects everybody else to, then he must do the needful. It does not in any way indicate subservience, like he is subservient to that of the Attorney General. It doesn't indicate so. That is what the law says. So he must be seen to be abiding by the law. So going there, I don't want to think that he may have X splashed on his face. Maybe the Supreme Court may have a shrewd way of handling the matter. And that in itself may settle the issue. But until Article 88 is amended, I think that the law is still the law.
Thank you for your time this morning, and we wish you a blessed weekend as well. There you heard Dr.
Thank you,
Jonathan
Randy.
Asante Ochre. He is the Executive Director of the African Institute of Strategic Studies. He is also a senior lecturer at the UCC, a political analyst, joining the conversation. But let's wrap up with Professor Enoch Opoku-Antwi as well. Prof, your recommendations, what's next from where we are now? The special prosecutor says you file an appeal on this particular ruling. What next?
I think that is in order for him to file an appeal. Individuals being accused of any crime still have to file an appeal. It goes to an appeal court, and then it goes to the Supreme Court. That brings finality to the whole issue. It shouldn't go at the High Court. We should go to the Supreme Court, the apex court, to make the judgment. My worry here is that all by the OSP is being null and void. It means that everything that is done has come to naught, zero, cost 90 work. And that means the money we spend in that office and all the cases that it from this ruling that people see the judgment and then efficiency of the special prosecutor, not the office, but the special prosecutor. If that's the case, then we should also look at the way we appoint somebody to that office and the way we can get that person out of office if we feel that the person is not fighting for the interest of the country, but fighting for their own interest. These are some of the nuances that we have to look at. But I think that to bring finality to the issue, the office of the special prosecutor should appeal, and then the Supreme Court to make a decision. Then we should also make sure that Parliament do their due diligence in making any law, because the Constitution is the supreme law. And when we make laws to establish LI and bring any other, statutory institutions, in the end, we create loopholes in the constitutions, then we are not helping ourselves. So some of these things we should go and practice due diligence when we are making laws, and then we are amending those laws because they are very important to the nation. I remember that in America when slavery was abolished, they did not abolish it in all the states because they wanted to break away, but eventually they got there. So making amendments, or when you are bringing new LI, established statutory institutions, we should make sure that it goes in consonance with existing laws in our Constitution, both the spirit and the letter of it. And we will avoid all these drama that we are experiencing now.
It was actually the last one we were winding up, but just a quick one before we go. It just came to mind. I mean, if we are saying, if the court ruled that all that the prosecutions or the cases the OSP has handled can be, they are now ruled as null and void, what happens to the resources we have channeled into all of those cases, Prof?
Yes, it goes down the drain. It makes done zero work. And all the noise we made about the special prosecutor getting, having the mandate to prosecute individuals who are corrupt and politicians who are corrupt, it means we're just playing. We didn't mean it. And that's dangerous. That's very dangerous. So I think that what has happened should happen. The laws and the processes that he handled, if they were flawed, then we can look into it. But it seems to be bordered everything on interest, on personal interest or political interest or national interest. And in all situations, we should be thinking about the national interest. That is what will bring trust in the judicial system. And all Ghanaians will have the confidence that when anything goes to the court, they are sure of getting fair judgment in any of these cases. So yes, it's a sad situation. It's a very sad situation. People don't see it that way. It's good that you say that the OSP should go. One day somebody will come and talk about loopholes in the Auditor General's issues, their mandate, and we say that the Auditor General office should also go. Then what happens to the way we fight corruption? Because the Auditor General comes with a lot of findings about financial malfeasance and everything, but nothing happens. So the prosecution is our biggest problem in the country when it comes to graft. I'm talking about corruption. Yes, we find people who have stolen money here, who have put money here, building houses here, buying cars that their salary cannot finance. But in the end, who is prosecuted and who goes to jail? Nobody.
Thank you. Most definitely, it's a developing story. We'll catch up with you when there is a latest on this issue, Prof. Very well. So there you heard Professor Enoch Opoku Entry. He is governance and leadership expert, also adding his voice to this particular conversation. This debate will continue or linger on in your offices, in your homes, in the market, and even on the streets. The OSP versus Attorney General. And I put it just simple: are we going or are we coming? Well, let's see. Interesting days ahead, as the special prosecutor mentioned that he will be heading to the court for an appeal on this particular one. We'll keep our eyes on that particular one, and whenever there is a latest on it, we'll come back right here around the table to discuss it. Let me say a very big thanks to you for watching. Before I go, there's a birthday wish which should have come earlier, but it came a bit late, and this is from All Nice Adams and Fozia. They say happy birthday to you, Osman Maida of Accra. God bless you. And that's coming from All Nice and Fozia. Today's your birthday, Osman Maida. Enjoy your day to the fullest. A big thanks to the crew also for putting this one together. It's a Friday. Please stay safe, stay out of trouble. Let's meet next week. My name is Randy Ahadzi. It's a wrap for now.